Hello and welcome to the Advanced Decisions and Ethical Choices project. This project is about helping you make decisions or express preferences that can help with treatment decisions when you lose mental capacity. But what does it mean to lose mental capacity? Mental capacity is the legal term for your ability to make decisions about yourself, including decisions about medical treatment. Now, the law on mental capacity differs from country to country and also between different parts of the UK. So in this video, we'll just be focusing on mental capacity and medical treatment in relation to the law in England and Wales. First of all, the law in England and Wales presumes that everybody has mental capacity unless it has been proven otherwise. You cannot be assumed to have lost mental capacity just because of your medical condition, your age, or even because doctors or others think that you are making unwise decisions. It has to be an assessment carried out, for example, by healthcare professionals. Secondly, mental capacity is also specific to each decision. So somebody could have been found as lacking mental capacity to make decisions about more complex medical treatment, but might still be considered to have the mental capacity to refuse or consent to simpler or more routine treatments. Thirdly, mental capacity assessments are also time-specific. It is not assumed that somebody who has lost mental capacity has lost it permanently. Somebody who has lost mental capacity could still regain that mental capacity. To assess whether somebody has mental capacity or has lost it, healthcare professionals will take into account factors such as your ability to understand the information relevant to the decision, your ability to remember that information, your ability to weigh up that information, and lastly, your ability to communicate your preferences or your decision in relation to that information. Losing mental capacity for the purposes of the law has to be the result of an impairment or a disturbance in the functioning of the mind or the brain. This could be as a result of a condition such as a stroke or dementia. But once again, remember that mental capacity assessments are decision-specific and time-bound. Just because somebody has any of those conditions does not mean that they have lost mental capacity for any decision or all decisions. Only when mental capacity is lost do doctors make decisions on the patient's behalf. Now, if you have an advanced statement in place that sets out your preferences, values, and wishes, then doctors will consult that advanced statement in order to make what's called a best interests decision. That is, a decision that takes into account both clinical and non-clinical factors about your well-being. But once again, remember that an advanced statement can be helpful even when you have mental capacity, but perhaps you don't have the energy to communicate your values and preferences. On the other hand, a lasting power of attorney and an advanced decision to refuse treatment will only apply when you have lost mental capacity and when the circumstances described in those documents apply. And they will also only apply to any specific treatments that have been named or described in those documents. So please check out our videos on those tools if you want to find out more about advanced statements, lasting power of attorney, and advanced decisions to refuse treatment. You can find these resources by logging on to our website at www.bioethics.org.uk. Thanks for listening.